Hello and welcome to the group presentation of our course Business and Corporations Law. So in this group presentation we are actually highlighting the breach of companies directed duties under the Corporations Act 2001, and as an example the case that has been taken is a case of Mr. Nasser versus Innovative Precasters Group Petty Limited. Our group members are Mr. Matthews Pasi, Ms. Kumit Kaur, Abu Bakr Ilyas, Muhammad Faizan Haider and Muhammad Arsalan Afzal. So moving further with the presentation, we'll be going to the introduction and what happened in the case and leading to the conclusion of that particular case. So starting with the introduction of that particular case. So the case of Mr. Nasser versus Innovative Precasters Group Petty Limited is considered as one of the classical case in the words of Honorable Judge Mr. Barrett. The people that were actually in this case were Mr. Nasser, Mr. Grasso and Mr. D'Olivria. This case is linked to the affair of three different companies that are named Innovative Precasters Group Petty Limited, IP Group Petty Limited and DGN Investments Petty Limited, and these are owned by these three people. IPG was registered on 7th of September in the year 2000, DGN was registered on 13th of November in the year 2000, and the Precasters Group was registered on 8th of February 2007. Mr. Nasser, Mr. Grasso and Mr. D'Olivria were the only director of these three companies. So actually what was the relationship between Mr. Grasso, Mr. Nasser and Mr. D'Olivria? So in this slide we are going to highlight the relationship, that what is the relationship between these three persons. So Mr. Nasser and Mr. D'Olivria worked together in the 1990s, and the company in which they worked, there was Gerard Precast. That company manufactures precast concrete panels. Later on, Mr. Nasser and Mr. D'Olivria, they left that company and they aimed to start their own business ventures. Mr. Grasso, he introduced Mr. D'Olivria and was also introduced by Mr. Nasser. And upon the recommendation of the experts, IPG Petty Limited and DGN were registered in the year 2000. And their aim was to manufacture precast concrete panels and to act as an investment vehicle respectively. Initially, Mr. Grasso held 75% of the share in IPG and 50% of the share in the DGN, whereas Mr. D'Olivria took the remaining shares. Later in the year 2000, Mr. Nasser became the shareholder and director of the company, and the shareholding of all natural shareholders stood equal. Thereafter, based on the agreement, Mr. Nasser, Mr. Grasso and Mr. D'Olivria. So from year 2000 to year 2007, Mr. Nasser handled sales, accounts and administration, whereas on the other hand Mr. Grasso participated in the investment activities and Mr. D'Olivria managed in the production business. In the November 2007, after an interaction between Mr. Nasser and Mr. D'Olivria, Mr. Nasser actually looked the possibility to withdraw himself from that business venture, after which the remaining two directors sent an offer to buy the shareholdings that were actually held by Mr. Nasser and the company controlled by him subsequently. However, Mr. Nasser initiated the process to realize the proceeds from the assets, which is followed by other two directors, but in different manners. So actually Mr. Nasser was trying to get it from the assets so that he can have up some proceeds from the sale of those assets. So what happened is, in order to initiate the process of the sale, a liquidator was appointed. So a provisional liquidator, after his appointment, established that IPG had not entered any new contract after year 2000 and decided to sell the business of IPG. The IPG was sold to Mr. D'Olivria after reviewing the fairness of the bid. However, in relation to GPG, provisional liquidator found that GN is the creditor of IPG, an amount greater than the aggregate of the trade receivables of the IPG and the proceeds of the sale of IPG business. In the opinion of a provisional liquidator, IPG was insolvent at that time. So how actually the breach of duties occurred and what was the reason behind the breach of the duties? So the duty requires that the partners not to, without reasonable cause, conduct themselves in a manner likely to destroy or seriously damage the ongoing relationship with other partners. In this case, although no partnership agreement was entered among Mr. Nasser, Mr. Grasso and Mr. D'Olivria, three parties were entered into a quasi-partnership. Such quasi-partnership requires to maintain understandings between the members at the time they entered association, mutual cooperation and trust among Mr. Nasser, Mr. Grasso and Mr. D'Olivria were deteriorated due to physical conflict between Mr. Nasser and Mr. D'Olivia, followed by the trust breaking activities. Lord Hoffman O'Neill versus Philip referred that where shareholders have to enter into an association upon the understanding that each of them who has ventured his capital will also participate in the management of the company, and will usually be considered unjust, inequitable, or unfair for the majority to use their voting power to exclude the member from the participation in the management without giving him the opportunity to remove his capital terms. So, in this case, Mr. Grasso and Mr. D'Olivia did not allow Mr. Nasser to visit the business premises without notice and access to the books of account. So, the section 232 of the Corporations Act 2001 provides that while minority investors regularly have zero capacity to impact the undertaking of an organization, the director must nonetheless act fairly between the shareholders and ensure their decisions to promote the interests of the company and shareholders generally, not just to majority. In this case, Mr. Grasso and Mr. D'Olivia, along with the companies controlled by them, were the majority shareholders, tried to remove Mr. Nasser from his directorship. So, the analysis of the court decision, under the light of the fact, what was the basically analysis that court come up with? This case involves the proceeding of the winding up in relationship to three companies, which, as I told you, and Mr. Nasser, Mr. Grasso, and Mr. D'Olivia actually hold. So, these companies were, as you know, IPG, that DPGN, and the Precasters Innovative Petty Limited. The court separately considered the fact and circumstances related before making such verdict. So, in consideration of section 467 subsection 4, the court determined that to dispute was compulsory acquisition of the applicant's shares by the other shareholders of the company. However, there have been occasions where this option is considered impractical, where the financial situation of the shareholders would prevent this, and winding up is the only viable option, dissolving a deadlock. So the winding of the three companies was initiated. In this case, the court considered a relief to Mr. Nasser that Mr. Grasso and Mr. D'Olivia, after purchase of the share of IPG and the Precaster Group held by Mr. Nasser, the company controlled by him or by making some other fair arrangement. However, there was nothing before the court to show that either of Mr. Grasso and Mr. D'Olivia, in their individual capacity or together, could, as a manner of their financial capability, purchase Mr. Nasser's share in the business. Further, since IPG was already under provisional liquidation and the assets of IPG were sold by the liquidator that was appointed initially, buyout option seems impermissible as a matter of jurisdiction. The same condition applied to that Precast Innovative Group, as the company has no business and assets subsequently. However, in case of DPG, company was not appeared to be insolvent as it owned real assets for sale or generating rental income. Therefore, in the interest of Mr. Nasser as oppressed shareholder, the court vindicated the winding by selling the assets at arm's length price, and after selling, the debts surplus to be distributed among the shareholders. So, on the analysis of the fact and the evidences considered, the court in the evidence that involvement of different just and equitable grounds shaped the decision of winding up by the court of these businesses. So what was actually the effect of the judgment? So under the section 461 subsection 1K of the Corporations Act 2001, it said that the court has the power to wind up a company and to appoint a liquidator if the court believes it is just and equitable for it to do so. This case extends the scope of just and equitable grounds to quasi-partnership as well. Now, in case of a breach of a mutual trust and cooperation among the shareholders, working as a quasi-partner could demand for the winding of the company if there is no other feasible and exercisable option left in this case, which wasn't any. So, while concluding, we can say that the case on the grounds of the oppression of the minority shareholder relief under section 233 of the Corporations Act were demanded by Mr. Nasser. However, Mr. Nasser failed to show them that is oppressive, unfairly and prejudicial or unfairly discriminatory conducts of the majority of the shareholders. However, the court admitted the alternative of the winding up given by Mr. Nasser in accordance with the section 461 subsection 1 and 461 subsection 1K of the Corporations Act 2001. Therefore, just and equitable grounds were used as a base by the court for winding up the orders. So that was actually what happened in this case, that how actually dispute started, how the business started, how the dispute started among the people, and how actually that leads to the winding up and the liquidation. So court appoints a liquidator as per the Corporations Act, and all the proceedings were done. So that was all to this whole case. So thank you very much for listening to us. Thank you, and you have a good day.